The petition to appoint conservator. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine State Court Administrative Order Form PC 639. SCAO Form PC 639, PC for Probate Court, is the petition that can be used for both the establishment of a conservatorship as well as a protective order in a protective proceeding. Now, with all of these SCAO forms, they are created by various statutes and court rules. As you can see from the arrow at the bottom right corner that's floating across your screen, these particular statutes and court rules, there's quite a few of them here for this particular form. You should understand these statutes and court rules, and we're going to try to give you a broad-based understanding and perspective of when to use this particular form. But again, to really understand it, got to read the statutes, got to read the court rules, and understand what the usefulness of this form is with the guidance of an attorney. So to understand a conservatorship versus a guardianship is kind of step one. To guard, guardian, that's to guard or to protect an individual for their care and well-being needs. Conserve, conservator, think of conserving money. Conservatorship is for financial and for legal. Now, many people think of the word power of attorney. And yes, a power of attorney is an effective estate planning document that can be created when an individual is of sound mind. But when they lack capacity and they're no longer able to generate or create a power of attorney, a protective proceeding or conservatorship proceeding will be necessary to protect their financial assets, for them to make legal decisions about lawsuits and otherwise, and to handle any of their financial affairs. So guardianship, generally for care, there are certain roles that a guardian can play relating to money, but generally a guardian cannot manage money, and a conservator relates to money and financial affairs and legal affairs, but not for care. They can be the same person performing both roles. You can have a guardian without a conservator without a guardian, and you can have two different people performing those various fiduciary roles. Now, a protective order is not a conservatorship. A protective order is an order that specifically addresses a particular financial issue of an individual. A conservatorship is an ongoing proceeding that will remain in effect until such time as a court order terminates or ends that conservatorship. So let's walk our way through the form. In the top left corner, you'd identify the county in which that individual is a resident, the individual upon which you're seeking protection. Top right corner, it has a blue rectangle, but there's nothing you put here because the case number is going to be assigned when you file this with the court and pay the requisite filing fee. They'll assign a case number to this particular matter. So at the onset, when you're filling out the form, don't put anything there. In the red rectangle where it says conservator or protective order, you have to decide, are you seeking a conservatorship for ongoing administration or a protective order for a particular event? At the top, you'll see the estate of. Now, this is the individual upon which you're seeking protection. It may be an adult who is in need of protection, and it may be that a minor is coming into assets from an inheritance or a settlement of a cause of action, or they're receiving money for some reason that needs the court's protection. The last four digits of the Social Security number are provided there. If you see where it says B with a little circle, we're going to go through alphabetically kind of these steps. You identify the person who's filing the petition. And just like with a guardianship, the statute provides that anyone interested in the well-being of that individual can file and be the petitioner for purposes of the conservatorship. And then you identify the relationship you have as the petitioner to the individual upon which you're seeking protection. You may be a mother or father, you could be a case manager, you could be the neighbor who identifies that there's a need for protection for that individual. C gives some additional information about the individual upon which you're seeking protection. You're identifying their date of birth, where they're a resident, which county, and what address they're at. And if they're out of the state of Michigan or out of that county, if there's an asset in the county upon which you're seeking to proceed, you'd identify it where the property is located. As we move through sections D and E, D relates to whether there's an existing family court, family division matter in the circuit court that's already in place. If there is, for example, if there's a guardianship already in place or a custody matter that's already in place, you'd identify the name of the court as well as the case number upon which that matter is currently pending and what judge was assigned to it or is still assigned to it. This allows the court to group related matters involving the same issue to the same judge if appropriate. It also helps identify for the court the venue for purposes of identifying whether venue is appropriate. Section E identifies whether there is a power of attorney in place already, whether a guardian has previously been appointed, and whether there's a representative payee for Social Security. So if any of those fiduciary roles exist, you'd click those boxes in Section E. Let's move our way further down. Section F identifies for an individual that's an adult. So if you're dealing with a minor, you don't deal with Section F. But if you are, you'd identify which of the various bases or elements create the need for the conservatorship. Is it mental illness, mental deficiency, physical injury, or disability, chronic intoxication, chronic drug use, confinement, all sorts of various bases upon which the statute allows you broadly to identify the diagnosed reason for the creation of that protection. In addition, you have to assert that there's a risk that if there isn't protection, that there's going to be an asset that is at waste, meaning it can be reduced or lost or dissipated, and that there's a need for this conservatorship to ensure support, care, and well-being are protected. In addition, there's a basis for a conservatorship that the person is competent, but because of their advanced age or their physical infirmity, they're unable to manage their affairs effectively, and there is a need for a conservator. So you can imagine scenarios in which this may play out. In addition, you'd identify whether there is money or property that are in jeopardy because of their minority, which means they're under the age of 18 years old, and that they need money for example, for support or education, and protection is necessary. So again, you check the boxes dependent on whether you're dealing with an individual adult or a minor. In addition, if you are the guardian of the ward, you would identify that also in that section. The next section gives the court additional information about the supportive facts. So here you can write one sentence, you can attach additional documents, you can attach medicals that support the basis and need for that conservatorship. So for example, if the minor is receiving an inheritance of $50,000 and there's a need for a conservator to be appointed to protect the inheritance, you would simply write that information there. On the other hand, if it was an adult and they're experiencing dementia, you could write that information there. So again, you're giving more information to the court to understand the basis for this particular filing. We're going to now move to the back side of the document. And here, the court wants to know in this pleading various information about assets. So is there real property, land or a house? Is there personal property? This would include dollars in a bank account, financial institutions, and so on. Insurance, and what is the income that's coming in? So as we identify assets, there also may be income that's coming in from a pension or other sources. You'd identify that information there. Section I identifies whether you're receiving income from various sources, whether it's Social Security, SSI, Michigan Department of Health and Human Services, which is what MDHHS stands for, veteran benefits. And the reason for this is that depending on which information you check, first of all, it's going to give the court additional information about the income that's coming into the conservatorship upon appointment of a conservator. But also there are particular notice requirements for purposes of serving this petition depending on other agencies being involved. For example, Social Security, the VA, or the Michigan Department of Health and Human Services. If they're receiving benefits, there's a noticing requirement, and you should really look at the court rule MCR 5.125 and the related statutes to ensure that you understand the noticing requirements for purposes of this petition. As we continue to move down on the back side of the form, this is an identification of who has the right to notice, who has the right to become aware of the nature of this particular petition. And again, as you see, it's in order of identification based on their proximity and relationship. If there's a spouse, if there's children, descendants of the deceased children, if there's no children, then parents, and so on. And it generally follows the intestate process in terms of giving notice, but you should pay particular attention to the notice requirements as set forth, as I mentioned, in the court rule and statute, to ensure that you give everyone correct notice. And it's more than just simply fulfilling your legal responsibility, which you are required to do when you fill out this form. You can't just pick and choose people in the family that you want to give notice to and others that you don't. And unfortunately, that gets you into a whole heap of trouble because you're signing this document under the penalty of perjury. So you have to include everyone, whether they're close with love or not close. You got to give them notice if they're required to under the statute. But what becomes really frustrating for people is that they show up to court for the day of the hearing, weeks, maybe even months after the filing of this document, only to learn that the matter gets adjourned because you failed to give notice appropriately. Very frustrating. Going down to court, taking the time off work or off your busy day, paying for parking, sitting there waiting only to learn that your matter got adjourned because you didn't fill out the form correctly or give notice correctly. So pay particular attention to ensure that you give good notice. In addition, if any of those people are under legal incapacity that are entitled to notice, you have to identify them there. And then you have to identify where the individual who is under or being sought protection, where they're currently being found, where they're living. Maybe it's at home, maybe they're in a hospital or a rehab center. You have to identify them. And what's important there is that you want to identify them there, but also keep updating the court, because at some point the court's going to appoint a guardian ad litem, most likely, to go out and do a visit to assess the situation relating to the petition and to write a report or recommendation to the court for the basis and need for this conservatorship. And if you don't identify the correct location, that person, again, may not be able to do their job. And then, of course, the risk is that this matter could get adjourned. So again, pay particular attention to that. Now, in addition, there may be a need for some preliminary protective provisions that you're asking of the court. Maybe that individual is at risk in some way. They're being exploited financially. Their house is at risk of being foreclosed on. There's an imminent risk that won't allow for the normal time frame upon which a petition for conservatorship or protective order would take. You can ask for those emergency provisions as to the basis. And again, there are very particular circumstances that the court may entertain those requests, but that information would be included in section M. Now, under that, for the remaining sections, N through the rest of the alphabet here, these are the provisions where you're asking of the court for certain things. You're asking of the court for that person to be under conservatorship. You're identifying who you're nominating as the conservator, because sometimes the petitioner may be nominating another person. Maybe if they're nominating another family member, a friend, a professional, somebody like that to serve in that role. And you identify their priority in their relation. In addition, if there is a need to protect immediately before there's a need for a full hearing, you'd identify that information in section O. And a protective order, for example, if you're not asking for a conservator, but rather for an order for a particular protective proceeding, you'd identify the basis or the reasons for those orders in that section. And again, you can attach additional documents if necessary. In addition, section Q allows for the appointment of a special conservator if necessary, and then the penalty of perjury clause. This is the clause that's included in all of the state court administrative order forms that says that you're signing that document under the penalties of perjury, that is to the best of your information, knowledge, and belief. So pay particular attention to the language here. Be accurate, honest, to the best of your information or knowledge or belief, or you're at risk of the pleading not getting accepted, or of course being at risk of perjuring yourself in that petition. There's a space for your signature as petitioner and address, as well as if there's an attorney for their information. Section S allows for a person who is being sought protection over. If they're over the age of 14 or older, they can actually consent to the nomination or nominate somebody to be the conservator. The statute gives a right for that person to actually make the nomination. So it's an important consideration that if the person's 14 or older and they're consenting to this, have them sign that particular provision. Now, this entire document is not simple to complete. We understand that. And many people start down this path and they don't have all the information or they don't know what to do. I urge you, understand the statutes, read the court rules, work with an attorney that is in this area, that understands protective proceedings, that understands conservatorships, because this is really step one of a multi-step process. After you file the petition, pay the filing fee, there's going to be steps that include meeting and maybe interviews with the guardian ad litem, service with a notice of hearing and proof of service, ensuring that you're prepared in advance of the court hearing, putting on your proofs at the court hearing, getting a letter of a conservatorship, maybe needing a bond for the qualification of conservator, getting an order entered and a letter of conservatorship, and then of course all the requisite steps when it means to be the conservator, which is a huge responsibility. So again, I urge you to work with a skilled, competent probate practitioner, and this is just the basics, the ABCs of this conservatorship process. And this particular form, I wanted to give you a broad understanding of how to fill it out and what you do with it. At the Probate Pro, we are passionate about everything probate. If you have questions about a petition for appointment of a conservator or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.